Okay. So last time we met, we talked about definitions of Homeland Security, and I have a couple of administrative announcements. On D2L, there's a calendar of when things are due, as well as a place where you can upload your reading responses. And I apologize that wasn't ready for you for the readings that you just did for today. So if you go to, under the Contents tab, if you go to Key Documents, there's now a calendar that shows when the various assignments are due. And I kind of pared things down a little bit. I had said that there would be 3 take-home exams. There's only going to be 2. And this shows when I'll be giving out the questions, which is like about 10 or so days before it's due. So the first take-home exam will be due October 23rd. Our first case brief will be due on September 25th. And if we go back to the content area, for the case briefs, we talked about the guidelines for case briefs, and I'll be posting later today the text of the Supreme Court opinions that you're going to read for the case briefs. And then the reading response assignments, I made a spot where you could upload each one of those. So I'm still working on getting the D2L thing up to speed. Can't say that I like it any better than I have in the past, but that's okay. So let me go back to, and then for today, we're going to talk about the content that you were reading about, the constitutional framework within which law and policy dealing with Homeland Security is made. So for this reading that you did, it talked about the way the judiciary operates, and they had you read a couple of excerpts from Supreme Court opinions to talk about the role of the courts. And I do put an emphasis in this class, since we're talking about constitutional issues in Homeland Security, I do emphasize the role the court plays in where there's ambiguity about what Congress can or can't do, or what the executive and the president can or can't do. The courts have often been the ones that have to step in and play referee to what are the limits of legislative or executive power, even in situations involving emergencies, and there are limits to those powers. So to have a constitutional government means that it's more than just saying, well, we have this piece of paper, this document or whatever. And we talked last time a little bit about entrenched constitutions like the United States has. An entrenched constitution just meaning that it's more difficult to change the constitution, the basic law of the country, than it is to just make a law. And yeah, it's complicated as it is to make a law. Both houses of Congress have to pass it, and by a majority, and the president has to at least not veto it. It's much harder to change the Constitution. And within that framework, as you read about, the courts have decided for themselves, based on what's hinted at in the Constitution, that the court has the power to say certain parts of the Constitution, or certain things that the executive, the legislative branch do go beyond the scope of the what the Constitution says, and therefore the court can strike them down or declare them null and void. But a constitution in of itself means, if there's a constitutional government, it means that both the citizens and the members of government are under the rule of law. So any kind of government that has the word constitutional in it, you know, so you can have Great Britain as a constitutional monarchy. You can have monarchs and have them within a constitutional system, because it means that once that basic law is set, that they have to follow the rule of law like everybody else. And so the reason why I pay particularly attention to the courts is because the courts are the ones that articulate those doctrines. So in our, I do want to talk a little bit about Marbury versus Madison, which you had in your reading. And by the way, one or two of you are still having trouble, you know, haven't gotten the book yet. I got an email just now. That's fine. The way I set up the, where you can turn in the readings, I'm not going to take off points if it's a little late, because I know that some of you are still in the process of getting your books, and that can take a little bit of time. Excuse me for a second. So, I don't know, did you find Marbury versus Madison, that excerpt, hard to understand? It's okay if you say yes. So let's do this. Do you guys have the thing where you can vote yes or no? Like, do I have to do something to make that? Okay.
Are you asking about polling?
Not the formal polling, like where there's a question, but not sure what it looks like on somebody that's not the host, but like the ability just to click like a yes or a no. There is the official polling, like where I create a question and we do that. I suppose.
Do you mean in the participation where you can, like, I'll push yes, and then you see a little check?
That's where, Adriana, where do people find that?
So you'll see participants at the bottom of your screen. If you hit that, then the bottom of it says raise hand, yes or no, go slower, go faster. And if you hit yes or no, it turns up.
And Cameron, thank you. I just saw your chat about, yeah, you can use the reactions as well. So how many of you found, well, yeah, we could do just like a thumbs up. How many of you found that it was a confusing case to read about? So everybody thought it was awesome? I'm sorry, now I'm working with. What is this invite thing? Ah, got it. Okay. So some people did. So anyway, basically, the Constitution, the one power the court has is the power of judicial review. And the power of judicial review is the power of the courts to say that something that the executive or the legislature did is unconstitutional. And it's not, or to strike it down, as we say in regular language. And it's not articulated in the Constitution anywhere that, you know, this phrase judicial review, but in Marbury versus Madison, the court said that it's implied in these other parts of the Constitution. The court said it's implied by the fact in Article 6, it says that this Constitution is the supreme law of the land, and things that are inconsistent with it, either something the national legislature or executive does, or things that state governments do that are inconsistent with it, are null and void. And they combine that with Article 3, which says that's the one that creates the courts. And it says that there will be a federal court system and it will have the power to say it will have the judicial power. And the judicial power historically has meant that courts say this is what the law means. And so they say the fact that they get the power to say what the law means, and the fact that the Constitution says the Constitution is the supreme law of the land, they say that implies that they are the branch of government that should get to settle those disputes. Like, so the way the Constitution is written, without their, they did have this thing that the that the federal Constitution was the supreme law of the land, but it's not like a natural law. In other words, what about if Congress or the president did something that was inconsistent with that document? It doesn't really say specifically what will happen. But so it almost kind of assumes that they wouldn't do those things just because they said in the Constitution that they wouldn't do it. And so the court assumed for itself a role as saying sometimes the executive or the judicial branch, I'm having a tough time, that the executive branch or the legislative branch will do something that's inconsistent with the Constitution. And then they have to say, you know what, you don't get to do that because it's inconsistent with the Constitution, and the Constitution is the supreme law of the land. And the first time that they used the power and articulated it was at the same time in 1803 in that case for which you read an excerpt, Marbury versus Madison. And I want to talk a little bit about the background. That came out of a political situation where, well, actually, we probably don't need to dig that deep into it. But so we know that the court gets to settle these disputes. So I wanted to look at the way I'm sorry, I'm a little bit befuddled this morning. I had done some written notes. I'm in my office, as you can see, and I left all of those at home. And there's, at home, I can access everything that's on my work computer, but I don't have the ability to do that the other way around. So when I forget things on my home computer, I need to remember to file them on the Microsoft OneDrive or whatever. And of course, I did not. So I was trying to get my thoughts together before, real quick between classes, and of course, got some phone calls and some emails. So I apologize for seeming a little befuddled because that's true. I am. So I'm trying to think about how deep I want to go into this. And some of the questions that I'm coming up with off the top of my head just aren't very interesting. Why don't I go ahead and start talking about the powers that Congress, the ability of Congress to make laws regarding national security and the limitations on Congress. So let me just get that for you. again, I apologize. Because I'm even having trouble finding the presentation I want to show you. Well, this is a pretty pickle that we're in, that I've put us in. Do you ever have one of those nightmares where you're speaking in front of people and you're naked or something? I'm kind of feeling like that right this minute. Let me look at one more thing over here. Okay, so yeah, I hate it because I'm having a bad day at this right this moment. I'll be fine. Somehow when I have these moments of forgetfulness, I like having them better in person than in this recorded format for some reason. Partly because I have thoughts of, I'm recording this and like, you know, the people will get to see me babbling. Perhaps today I'll just print some notes about what we talked about. In terms of the powers, let's just start. I'm going to just start talking about what it says we're going to start talking about for next week, which are some of the limitations on the various branches and checks and balances. So in our system, as you know from American government, we have a system that has separation of powers because that was one way they saw, instead of congregating all of the powers of government into a central authority like a king or a monarch, to separate out what each of these authorities, what each of the elements of what government does, because in essence, a government makes the rules, it enforces the rules, and then it applies or adjudicates the rules. And adjudicates is just a fancy word for what courts do. It looks at things one by one and says, yes, you're following the law, no, you're not following the law. So why not separate those out into separate individuals or groups of individuals, and then having them be separated? Government officials, human nature is such that it's always going to want to become more powerful. But by separating the powers, you use that jealousy over power, that sense of wanting to get power, but that sense of jealousy about power, you put that to work for you. And so each branch will be in a position to watch the other branches and say, hey, wait a minute, you know, the presidency just did this thing which it's not supposed to do. You know, and Congress will be jealous of the power of the presidency, and the courts will say, hey, wait a minute, that part of government just did something it's not supposed to do. And so separating the powers and then having checks and balances. So for things that every power that one of the three branches has, there's a power that the other branch has to check that. And so some of the examples are Congress can make a law, but the president can veto a law. And there's another check for that, because with enough support, 2/3 in both houses, Congress can override a presidential veto. And then the check is that the courts can declare a law unconstitutional. Some limitations on the power of the courts. The makeup of the federal courts, presidents get to appoint judges, but Congress, specifically the Senate, has the power to approve or not approve of those judges. Congress has another control over the courts by Congress is the one that gives the court, the federal courts, its jurisdiction. And there have been times in history, if courts were going afoul of what Congress wanted, they would say that the courts no longer had jurisdiction in a particular area. That's even happened sometimes as the courts were hearing an issue. Congress has changed the jurisdiction of the courts so that the courts couldn't hear something. And this whole idea of jurisdiction is an interesting one, and your textbook starts to talk about that. When can courts get into a battle over Homeland Security or anything else, but in our context, Homeland Security, and say, yeah, I get to step in and solve this problem about whether the executive has done something that's beyond the scope of what they can do. And it's this Article 3 of the Constitution, and let's take a look at that. Let me share this with you. So Article 3 of the Constitution sets out the federal courts, and let me make that a little bit bigger. It says it's getting bigger, but it does not look bigger. And it says that the judicial power shall extend to all cases and controversies. There's a lot of specifics in there, but it essentially says that the court shall have power in all cases and controversies. So what that means at its most general level is that the courts in the United States are not hypothetical courts. They can only get involved in some sort of dispute that comes up if it comes up in the right way. Not any dispute is justiciable, and that's the fancy word that we use for this. And let me, oops, I don't have the PowerPoints that I was going to use, and I don't have a chalkboard, but I can pretend like I have a chalkboard. And thank God I know how to type quickly. So let me share. Okay, so we're going to take a look at, we're going to consider something called justiciability, which is the authority of the courts to hear a case. Because this becomes a really big issue in the context of Homeland Security, because there's lots of issues that the courts can't even hear. So issues, especially when it comes to certain parts of secret surveillance or detention of non-citizen combatants. A lot of these cases can't even be heard by the courts because they're not considered justiciable. Justiciability just refers to the authority of the courts to hear a case. And there are four things that courts will consider. When something comes before them, one of the first things they do is they say, can this dispute be before us? And so the first thing that the courts have to consider is whether the person before them or the entity before them has standing to sue. And it's usually just abbreviated as standing. The idea of standing means that the person who's bringing the challenge to the law has suffered some sort of legal harm by the law. Again, our system doesn't allow for hypotheticals. Congress can't run over to the courts and say, hey, we're getting ready to write this law. What do you think? Would that be constitutional? They can't run over to the president. You know, the president can't run over to the courts and say, so we're getting ready to declare executive privilege. Would that be constitutional, do you think? Because it they are reactive institutions that only hear disputes that are brought to them, and they have to be in a certain format or else the courts won't hear them. So standing to sue means that the only person that can bring it, has that person been harmed in some way by the law? So for example, back in the 1970s, the Sierra Club, an environmental group, wanted to bring a suit against the Disney Corporation. The Disney Corporation had acquired some lands nestled into the Sierra Nevadas, up where Yosemite is, that was nestled right up against public, federally owned parklands. And Disney wanted to make like a Disney style ski resort, which of course would have had a huge footprint and a lot of cars coming and going. And although it wouldn't have been on the nationally protected lands, it would have certainly impacted them in a negative way. And so they wanted to bring a lawsuit to say that, that they shouldn't be able to do this because the law protecting those lands would protect the impact of what they were going to do. And so before they get started, they said, well, you as just this special interest group, do you have standing? And they said, well, yeah, because, we're the Sierra Club. We're named after the Sierra Nevadas. For 100 years, more than 100 years, we've had these concerns about the environment. So yeah, this is what we do. And the court said, that's too tangential. Now, this case also illustrates the point that sometimes it's little more than a legal fiction whether or not an entity has standing, because the Sierra Club regrouped and they brought the case again. And this time, instead of filing it on behalf of the Sierra Club as some sort of theoretical entity that had an interest and was being harmed by the action taking place, they, on behalf of a dozen or so members who regularly used the national parks and whose enjoyment of those national parks would be imperiled by what Disney was going to do, they said, we as individuals, we're going to be, suffer this harm. And so we have standing. And the court said, yeah, in some ways it was the same thing, but you just have to have somebody who's going to be harmed. The court does not hear hypotheticals. So the first element of justiciability is who's able to bring things to challenge them in court. The next two issues are related because they both have to do with timing. And there's ripeness and mootness are our next two issues. So these are both sides of the same coin. Ripeness means you can't bring a case too soon before it's ready, before it's ripe. And so it can't be an issue that maybe could happen, but in the future. So for example, this made cases involving a lot of states up until the 1960s prohibited the sale and manufacture of contraceptives. And so it made it really hard to challenge these laws, partly for standing reasons, like, well, who's going to challenge it? Doctors tried to challenge the contraceptive laws, and they said, well, but you're not really the one being harmed. And so then they said, well, how about couples? And so this one couple challenged a law in Connecticut, saying that Connecticut's law that prohibited not only the sale and manufacture of contraceptives, but the use of contraceptives. A married couple filed a suit saying that the law was unconstitutional. And they said, yeah, you have standing because you are a married couple. And they said it was chilling their marital relationship. The woman in question had a health condition, and her doctor had said if she were to become pregnant, it would threaten her health, maybe even her life, if she were to become pregnant. So they said, we're being harmed by this law. The court said, yeah, you do have standing, But they said this issue isn't right. You're saying if your wife were to become pregnant, it would threaten her health, her life. But she's not. It's still a hypothetical. The issue is not concrete yet. So an issue has to be ripe, meaning you have to wait until something has actually happened before the courts will hear an issue. But by the same token, regarding timing, it can also be too late. And mootness gets at the idea that you have to wait till the issue is real and it's happening now, but you can't wait until too long because then it will become moot. To be moot means the passage of time has settled the matter to the extent that there's nothing left for courts to do. Courts will only get involved if there's something, some legal thing that they can do about a dispute. They're not going to weigh in and just say, oh, that's too bad, that shouldn't have happened. There has to be a legal remedy left for them to do. So for example, mootness was a real problem when it came to challenging laws that banned abortion. So they were, people who wanted to challenge those laws were able to pass the standing and ripeness bars, but not the mootness bars. And here's why. So the only person who would be able to challenge an abortion law would be a woman who lived in a state that banned abortion and who became pregnant and wanted an abortion but couldn't get one because the law prohibited it. Okay, she has standing now, and it's ripe because she would have to actually be pregnant and want to obtain abortion. So she's met 1 and 2 of justiciability and could even get that initial filing in court at the lower level, and they could either agree or disagree. But these issues are always going to go up the chain of courts. And by the next court, it would probably be too late, the next appellate court, let alone by the time the Supreme Court would hear a case. From when you file your original case until when the Supreme Court hears it, at the very least, it's going to be several months and usually years. And so what would happen is they occasionally would have a woman who, you know, lived in a state, became pregnant, wanted to get an abortion, couldn't, and she could file. But then when the challenges came, it was moot because she either would have had the child, she would have gone to another state or location where it was legal and had an abortion, or had an illegal abortion. There was nothing left for the courts to do because the legal remedies are for the court to either tell to, in this case, they're wanting a declaration that the law is unconstitutional so that they can do what it is they want to do, in this case, get the abortion. If they've either already gotten an abortion or have a child, there's nothing left in that case for the court to do, and the issue would be moot. And indeed, when the Supreme Court finally did hear an abortion case in 1973 in Roe versus Wade, of that 90-page opinion, the first 30 pages were devoted to the fact that they were going to say that the mootness issue could be set aside in very certain circumstances. The court never says, oh, just this once. So they said this was a special situation that if a person could have the same right violated by the same government entity, and if it would always be the case that it would be moot by the time an appellate court could hear it, they would waive the mootness issue. So what they were saying is the same woman later on could become pregnant again in the same state that prohibited abortion. So she could be claiming the same right, and the same government entity, the state that she was living in, could deny her the right. And because of the special timing issues with pregnancy, where that window is really pretty small, it's always going to be moot by the time an appellate court hears it. They said that they would then set aside the issues of mootness. So these are all issues that are really hard sometimes in a lot of national security contexts, because with the standing, with some of the, when it became obvious that certain agencies were collecting information about people without warrants, we didn't know who those people were. We just knew that they were collecting information. And so the groups like the American Civil Liberties Union, the ACLU, tried to say, well, we're going to have standing on behalf of X clients. They knew that certain people, that there had been warrantless capturing of their information, but they didn't know the identities of them. So they had tried to say, well, on behalf of 10,000 people who have had their information captured without a warrant. And the court said, that's not good enough. You actually have to know who the person is. But the people who had their information captured weren't told that their information was captured. So their right was being violated, but they didn't know, so they couldn't assert the claim against the government. And of course, the rightness and mootness issues come up in the context of national security. But another one that comes up in the issue of national security more than in a lot of areas is this last point, which is the point of political questions. The court from time to time has said that certain questions that's been asked, they will decline the ability to, or decline the opportunity to hear a case. Maybe that meets all these other requirements of standing, rightness, and mootness. Sometimes the courts will still say, we're not going to hear it, because they'll say this question is so very political that an unelected branch like the courts shouldn't step in and solve it. They should allow the issue to play out and allow the elected branches to solve this question for the people. Now, that's a pretty easy doctrine to articulate. You know, it's saying that certain things are so political that an unelected court says that we're not the branch of government that should be handling this. So I can define it pretty easy, and yet it's really hard to predict when they'll invoke it. The courts have invoked it at times that I thought, that's weird. I don't think you need to be invoking it. And yet there have been cases which I would have bet a year's salary they would have invoked it, and they didn't. And the big one was in 2000 in Bush versus Gore, where a challenge had come up out of the Florida voting districts to they were in the process, Florida had decided they were in the process of recounting certain troublesome precincts, and the lawyers for Bush said, you know, Supreme Court, that seems to violate some of these federal election rules. And I thought, you know what, there's plenty of time. The Constitution has all sorts of rules about if it's ambiguous about who wins. The court certainly isn't going to get involved in this question and stop a recount. That I would have bet my salary that they'd say, oh, this is a political question, we're not going to get involved. I was wrong. They did go ahead and get involved, although I felt a little bit vindicated when years later more than one justice on the court at that time said, you know what, we should have invoked the doctrine of political questions, because people really did see this as the courts acting in a very political way. So throughout the class, and particularly when we talk about issues in the news dealing with national security, one of the things in terms of the courts getting involved to clear up the rules is this whole idea of justiciability. It's not true that courts in all country refrain from issuing hypothetical responses. In fact, in some systems, a part of the process of an idea becoming an actual law, you know, it'll go through their parliaments and all of that process. And some systems, it then goes through a quick review by a constitutional court to make sure that it's consistent with that country's constitution and all its other laws. But we don't have that in the United States. They have to be these concrete controversies that are brought to the courts. And so what this means is, it means a whole variety of things. It means that there are probably laws on the books that would be in some sense unconstitutional if they could come before a court, but for some things it's really hard to get them before the court. Justiciability has been a big deal when it comes to issues about detainees in Guantanamo, whether or not those individuals are able to ask the courts to hear a case because of issues of standing and political questions doctrine. Okay, any questions so far?
Yeah, I had a quick question. Could you clarify ripeness for me real fast?
Sure. Ripeness just means it's an actual controversy, meaning the timing is such that yes, it's ripe, it's ready, the courts can hear it, meaning that it's not a hypothetical thing, it's something that has actually happened. And so in that one example about challenging the law against contraception, that married couple came up and they got standing because they were being harmed by this law. They were a married couple who wanted the ability to use contraception. And they said, look, at some point in the future, you're chilling our marital relationship. That was the harm, because we're afraid to engage in sex without protection because if the woman in the relationship were to become pregnant, it would cause all kinds of health issues for her. And the court said, it's not ripe, it's a hypothetical. Once she becomes pregnant and has these actual health challenges, then it's ripe. It has actually happened. Another word you could say is concreteness. It's not hypothetical. The issue has actually happened. And
that's perfect.
Okay, cool.
Thank you.
Sure. Any other questions? Okay. We're going to stop here. Hey, I really apologize for my bumbling in the beginning of this. This won't happen again. I see Adriana saying, yeah, I've seen you bad before. No, my apologies. You have your reading assignment, and again, if you are late with some of the reading assignments, that's okay. Just get them turned in and that will be good. And I think that's all that I have for you today. Let me see. Yeah. Okay. So my apologies. I will see you on Monday. I will be coherent on Monday. And I look forward to seeing you then.